I don't know what that means.
Well, I want to settle because I'm the cardholder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay.
What happens when a defendant walks into court and refuses to identify herself by the name listed in the case? That is exactly where this unusual courtroom hearing begins. The court is dealing with a case involving Jade Lean, but when asked to state her name, the woman before the judge gives a very different answer, identifying herself as a principal, card holder, and beneficiary, and almost immediately, the courtroom hits a serious problem: identity, representation, and competency. The judge makes it clear that this isn't something the court can simply ignore. If the attorney cannot establish that the person standing before the court is the individual named in the complaint, the judge warns that fingerprints could be taken to determine her identity. Meanwhile, the defense raises a completely different issue, whether competency needs to be evaluated. Then things get even more unusual. The defendant talks about being a principal and cardholder, claims she wants to settle the matter, and later challenges the legitimacy of the case itself. But the judge isn't going to decide everything based on those statements. Instead, the court orders a forensic evaluation and schedules a competency hearing, and that's only the beginning. Later in the hearing, the defendant makes a lengthy argument about alleged police misconduct, evidence, constitutional rights, and why she believes the case should be dismissed. The judge, however, has a very different view of what the court record actually shows. Watch closely, because the biggest confrontation comes when the judge directly addresses the repeated delays and ultimately denies the motion to dismiss.
Case People versus Jade Lean.
Case on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Lathan. Ma'am, would you state your name for the record, please?
I'm not Ms. Lathan, I'm principal. I am J. Ruth Bay, cardholder and principal of Jade Lean.
Your Honor, I did attempt.
Mr. Overwater, while she's given that, is this the person that you know to be the individual named in the complaint? If not, we are going to have a problem, and I will have this person, since she got up here, taken into custody. We will do fingerprints and we will determine her identity by our standards. So we can do it one of two ways.
Judge, I don't question that she is physically the person that is alleged to have committed these offenses. What I do believe is that there is an issue as to competency.
For the record, I do not know this man, and I did send him a cease and desist to not represent me. However, thank you, Your Honor. I am the principal and cardholder of Jade, Ruth, and Lathan, and beneficiary.
Very well. Mr. Overwater, you are on this case, so what do you wish?
Judge, I believe that at this point, the issue of competency needs to be raised. So I would ask for a competency evaluation. This matter be set over for a competency hearing.
I'm not
pursuant
asking
to the
for
statute.
anything, and that's, from the horse's mouth.
I'll need an order.
I did turn in my statement of fact so that there's more than the police record on the record. I have not harmed anyone, and the cameras will reflect that if we are to go that far. But I would like to motion to settle.
I don't know what that means.
Well, I want to settle because I'm the cardholder in X relation to the principal, and I do not want to be
I have
mistaken.
no idea what you're talking about.
Okay. I yield.
Thank you. Forensic evaluation is ordered. I'll order a competency hearing. I'll set that competency hearing for
June 6th.
June 6th, 2024, 9 a.m.
2020.
At this time, bond will continue. Mr. Overwater, prepare the order, please.
I will do that, Your Honor. Thank you.
Thank you.
Thank you, Your Honor.
Court calls case People versus Jade Lean.
Image Ganapka for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Lathan, who's approaching. Ms. Lathan, would you state your name for the record, please?
J. Ruth Bay, beneficiary of the principal.
Your Honor, I have spoken with Ms. Lathan several times. We reviewed some of the discovery. We are looking into some potential resolutions. I'd ask to adjourn the probable cause conference. I would ask for more than 2 weeks.
August 29th, 2024, 9 a.m. I'll continue. Thank you.
Thank you, Your Honor.
Case People versus Jade Lean.
Kenneth Overwater, Assistant Public Defender, on behalf of Ms. Lathan, who is approaching.
Your name, ma'am?
I'm J. Ruth Bay, the nationality of Moorish American, beneficiary of the principal Jade Lean, and I'm making this special appearance at District 15, Michigan Court of Law under threat, duress, and coercion. I'm asking the prosecutor to dismiss this case on the grounds that there is no injured party. Plus, I have the right to a speedy trial, and this is the 5th time I've made an appearance for this in the case in the court of law since February 2024 for the arraignment. Since the arraignment, when the Ann Arbor Police Department apprehended me unlawfully and kidnapped me, forcing me to take fingerprinting and a mugshot when I am not a criminal. Officers Morgan Parker, 15400, and AA Condolis, 02002, claimed I fit a so-called description and also violently attacked me and produced a false police report against my person. These officers falsely accused me of committing crimes that the tapes do not show me doing at all. These tapes do not show me doing at all any of the things that I'm being accused of, as I've never harmed another person in my life and certainly not an officer of the law. I disturbed the peace, and I have on file with public defender Kenneth Overwater right here to my left, a character letter from my former teacher proving that I've always been a well-behaved student, and have always gotten good grades and have no history of foul play or violence, which is still true to this day. My legal representation on the day of the arraignment on February 2024, who helped grant me my freedom on bond, has already stated on the record that I have no history of violent offenses, which is the truth, and I assume why I was granted my freedom from police custody. I would lastly like to say that on March 11, 2024, I was denied 2 main sources of evidence for my case via my personal FOIA request that would have easily shown my innocence. These 2 things are the mobile gas station cameras, and that will show the young boy already on the phone when I walked into the gas station. But either way, I was not at all acting out of the ordinary or belligerent. I was nothing but kind to everyone in that store. And I'm nothing but peaceful, and I'm saddened that I have been accused of behaviors that are not true. And I would like to exclaim that I'm a victim of a false 911 police call when I had no idea I only know that because of the police report that I got after the fact. I humbly ask both the prosecutor and the judge that this case be dismissed because I have school and I have church to attend, and my college studies have already began on August 26th at the community college. And I'm asking you to grant me my justice from this, taking up my time, because my time is very valuable to my community and I would once again like to motion to settle this case for full dismissal in a speedy manner, because this case has already been in default judgment since.
This is where the defendant has finished presenting her side, and now the judge brings the discussion back to something much more concrete, the actual court record. The defendant has raised a long list of allegations, including claims that police unlawfully detained her, that officers attacked her, that a police report was false, and that important surveillance footage could have supported her version of events. She is also asking the court to dismiss the case, arguing that there was no injured party and that the proceedings have already consumed significant amounts of her time. But there is an important distinction here. Those are allegations made by the defendant, not findings established by the court in this transcript. The judge's response focuses instead on the procedural history of the case. And according to the judge, the delays were not requested by the prosecution, they were requested by the defense. That distinction becomes critical, because the court is now deciding whether there is a basis to dismiss the case at this stage. The judge says the court has reviewed the file, has heard what the defendant presented, and then delivers a very direct ruling. The motion to dismiss is denied. So here's the question. After hearing both sides, do you think the judge correctly focused on the court record and procedural history? Or should the defendant's allegations about the police and missing evidence have received more attention at this stage?
Since the date of March 7, 2024, and I
All
yield.
right, so that we know that the review of the court's file, I've heard everything that the defendant has said. Court's review of the file, that none of the requests to adjourn were at the request of the people. It was always at the request of the defense in terms of any delay in these proceedings. Secondly, I do not need a response from the people. If I consider that a motion to dismiss, that motion to dismiss is denied. Where do we need to go now, Mr. Overwater?
Just be asking for an adjournment of the probable cause conference.
Any objection from the people?
No, Your Honor, I have offered a misdemeanor offer of 1 count of attempt resisting obstructing the police. I'll leave that offer open to the next CCC.
September 19th, 2024, 9 a.m. In this matter, thank you.
Thank you, Your Honor.
And that brings this courtroom appearance to a close. But there are several important takeaways from what we just watched. At the beginning of the proceedings, the court faced questions about the defendant's identity and competency. The defense raised the issue of a competency evaluation, and the judge ultimately ordered a forensic evaluation and scheduled a competency hearing. Bond was also continued at that stage. Later, the defendant returned and presented an extensive argument for dismissal. She disputed the allegations against her, accused police officers of misconduct, questioned the evidence, referenced surveillance footage and FOIA requests, and argued that the case was interfering with her education and other responsibilities. Again, those were the defendant's claims. The transcript does not establish those allegations as proven facts. The judge then reviewed the court file and specifically stated that the delays had been requested by the defense rather than the prosecution. Based on that review, the judge denied the motion to dismiss. The case was therefore not thrown out, and the defense requested another adjournment of the probable cause conference. The prosecution stated that it had offered 1 count of resisting or obstructing the police and would leave that offer open until the next conference, which was scheduled for September 19, 2024. So what do you think? Was the judge right to deny the dismissal and keep the case moving? Or should the allegations about police conduct and disputed evidence have changed the outcome? Drop your opinion in the comments. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.